Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. The series this semester, we're looking at the First Amendment. I'm teaching First Amendment law. My primary focus has been on the speech clauses. So in the last clip we did a look at the Establishment Clause, and this time we're going to do a look at the Free Exercise Clause. There are actually some other courses at my school that cover the religion clauses in more detail, but I wanted to be sure my students had at least an overview. Now, before we get started, I want to do my usual spiel. There are lots of cases interpreting the First Amendment, but all explanations here are my own and not to be ascribed to my school or my students. For informational purposes, I will tell you though that I've been teaching at Mississippi College School of Law for many years. I've taught at law schools and business schools. I'm in about my 30th year, something like that, of teaching, but all the explanations here are my own. Let's get right to it. There are two religion clauses in the Constitution: the Establishment Clause, the separation of church and state that we talked about in the prior video. And here we are going to talk about the Free Exercise Clause. The language from the Constitution: Congress shall make no law prohibiting the free exercise thereof. Now, we have to remember a couple of things before we get started. First, remember that one's right to believe is more protected than one's right to act on that belief. Government may have some interest in prohibiting your right to act on your belief, as we're going to consider in some of these cases. So the right to act on one's religious beliefs is not absolute. Okay? Now, the other thing to remember about the Free Exercise Clause is it protects sincerely held religious beliefs. But there is some debate as to what that means. What does it mean to have a sincerely held religious belief? Now, for those of us who do have sincerely held religious beliefs, we often frame it based on our own experience. So there are questions like, what does it mean? Do you have to be a member of a formal church, of a denomination, in order to have a sincerely held religious belief? Do you have to believe in God? Do you have to believe in a supreme being in order to have a sincerely held religious belief? What about the following? Must there be a large following? I mean, some people have said, well, when Christianity first started, there was no large following, was there? So what about your belief has to be embraced by others? Is that a requirement to have a sincerely held religious belief? And as we're going to see in some of the cases, does your belief have to be consistent? Meaning, if you say you believe in all of these things, must you always act that way in order to have a sincerely held religious belief? All of those are questions that the court has struggled with. The conclusion we have is that it must be a sincerely held religious belief. And some of the beliefs, many of the beliefs are based on faith, and faith may be something that is not seen, right? The substance, what is the evidence of things not seen, about things that are hoped for. So this area gets to be a bit difficult for the court in order to just define what free exercise means. A third point is that when we define it from our own frame, sometimes what that results in is that people who believe like us, or maybe like the majority, we respect those beliefs, but maybe we don't respect the beliefs of those who believe differently. The court struggles with all of these things in its cases. Okay, so let's go right to it. So the first case we are going to talk about is called Reynolds versus United States. It's a rather old case. It's from 1878. But in this case, there was a Mormon, and he wanted to practice polygamy. Polygamy means that he was going to be married to more than one woman at the same time. And there was a federal law against polygamy. So he argued that he had a right to free exercise of his religion. And with free exercise of his religion, he had a right to violate the federal law without penalty because his belief was in the religious value of polygamy. So the question is whether the law that was regulating his conduct, not allowing him to be married to more than one woman at the same time, whether it was constitutional or not. And the court held that the law was constitutional. The court upheld the federal law banning polygamy, and the court said that while Congress cannot regulate one's opinion, Congress can regulate your conduct pursuant to that opinion. In other words, one's right to believe is protected more broadly than one's right to conduct based on that belief. Now, we've already talked about earlier the West Virginia versus Barnett case, also from the 1940s, where the court held that the government could not punish a school student for refusing to salute the flag. And remember, it had that language in the case, if there is any star in the constitutional constellation, it means that government cannot tell you how you must believe. So in the opinion, the court said that government cannot compel a person to confess by word or act on their fate. So here, government could not constitutionally force the student to salute the flag. Oh, there are some more cases too. Let me ask you about this one. So let's say that there is a person who is a Sabbatarian, which means they worship on the Sabbath, which we refer to as Saturday. And so this individual, in practicing their faith, refused to work on a Saturday. And as a result, they were fired. And when they were terminated, they applied for unemployment benefits. And the government refused to pay them their unemployment benefits. So the question is government denying her the free exercise of her religion by refusing to pay her the unemployment benefits where she was fired because she wanted to act her fate? The court said that she was entitled to her benefits. The court said that refusing her the benefits was forcing her to make a choice, either her job or her fate. And so therefore, she was entitled to receive her unemployment benefits because she was terminated, for the free exercise of her religion. But there's another one. Okay, so it goes back to my earlier question: must sincerely held religious beliefs be fully consistent? So there was a man, Thomas, who, as a part of his religious beliefs, did not believe in war. He was and did not believe in weapons. So he was working at a place that made weapons, but he was working in a division that where he wasn't directly involved in making the weapon. He was working in another unit doing something else. And something happened and his unit or his division was terminated. So they told him, if you want to keep your job, you're going to have to make weapons, which he said was against his fate because he was in opposition to arms. So he was terminated, and then he filed for unemployment benefits, and his request was denied. The government said, how can he have a sincerely held religious belief in opposition to arms, to weapons, when he was working at this plant? And he said, I have a sincerely held religious belief, but I was comfortable with the idea of working in the other division where I was not hands-on making weapons. So what result? What do you think? Should his right to exercise his religion by working somewhere in the company be respected? Or do you say that he didn't have a religious belief in opposition to arms because he was working for a company that made arms? Well, the court in this case said, pay him his unemployment benefits. The court talked about how in the free exercise of our religious beliefs, we may not be completely consistent, right? And not being completely consistent does not mean we do not have a religious belief. So here, the court used strict scrutiny, a high level, that government, and let's go back, the general rule where free exercise rights are involved, government may not intrude upon those rights unless it satisfies a high level, compelling governmental interests, and that the restriction is narrowly tailored to the interests. So you see, is free exercise a little easier than the Establishment Clause, where I went through that whole page of tests with you, right? But here, the general rule is that strict scrutiny is the test. And the court said that the government regulation here denying him his benefits did not meet strict scrutiny. Now, the cases, I've given you the names and dates of all of the cases below in the text box, but they are quite interesting as the court gives respect to some beliefs, and in others, the court says that the government has met its standard. Let me give you another one. Here in a case called Hobby versus Unemployment Appeals Commission, there was a situation where someone was hired who did not have certain religious beliefs. Then during the course of their employment, they converted to a particular religious belief, and they wanted their beliefs protected. And so they were terminated, they were denied unemployment benefits. So the government said, Well, they didn't have those beliefs when they started work. When they started to work for that company, they did not have those religious beliefs. Therefore, they do not have to be protected now. But the court said, no, 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 no. The court said, we decline to single out the new religious convert for less favorable treatment. So even though the person was not a religious convert when they were hired, when after they were hired, they became a religious convert, their rights of free exercise ought to still be protected. So now, in some cases, the court holds that the rights of free exercise do not prevail, that the religious beliefs, that right to express them in a certain way, do not prevail over governmental interests. And looking, as I was talking to you, I was thinking again about my uncle I told you all about before. My uncles were really amazing people, and many of them served in the military. Now, my mother's oldest brother, I told you about him. He was a leader of a local branch of the NAACP. So he had been called into military service when we had the mandatory draft, and he went in and he served. Then after he came out of, completed his, what's the language, his tour, his service, he had been preaching, going to churches and preaching for a good while from his boyhood, but then he had become an ordained minister, and he was married and all of that, and they called him into service again. So he went to a hearing and he said, I am now an ordained minister and I do not believe in violence. He said, I do not believe in violence. I do not believe in fighting. I fought before in the war. And so therefore I'm asking for an exemption. And there were exemptions for military service based on being a conscientious objector and also other exemptions. So the recruiting officer said, so you're a minister? He said, yes. And the officer said, you take your ministering to others seriously? He said, my uncle said, yes. He said, you like to help people with their struggles and their difficulties, their spiritual struggles and others. My uncle said, yes, like he's really understanding me, right? But then the recruiting officer said, okay, I'm not excusing you. And my uncle was quite surprised. But then the recruiter said, well, you said you want to help people. You're going to serve, but you will not be required to carry a weapon. You're going to serve and you will be a chaplain. And you will be a chaplain in the service, but you're going to go in. You have no choice. You must go serve. So he went in and he served, and he was a chaplain and helped helped others with their spiritual and other struggles. But I always thought that was a very interesting and factual story that he told to us. So here, look at these other instances where the court did not grant the individual the protection that the individual was seeking. So one case I have here is the Gillette versus US. And this was in the 70s during the Vietnam era. And there was an individual who sought to have a conscientious objector status. But he said that he was a conscientious objector to certain wars, but not all wars. Like he would go and fight, but there were some wars he refused to fight in. And so he sought to be based on his religious opposition to be released from service. And the court said, no, Congress can still draft you because you're not totally opposed to fighting. You're opposed to fighting certain wars. And so Congress can still force you to go fight. A fascinating case. I've given this the information at the bottom of the page. Now, another one, Bob Jones University. So the Internal Revenue Service, they give certain tax exempt statuses to certain types of nonprofit groups. So here we had a private school, a private religious school that would have been entitled to the tax exempt status. In the last clip, we talked about how that is not in violation of the Establishment Clause. But here, this particular school discriminated based on race. And they said that it was part of their religious beliefs. Their religious beliefs that Blacks should not attend their school. And that was the part they wanted to exercise their free exercise rights. So they wanted a tax exemption, although they refused to allow Blacks to attend their school. And the court said, no. The Internal Revenue Service can deny you this status. The court said, now you can discriminate if you want. You don't have to allow anyone but whites to attend your school. That is your religious view. But the Internal Revenue Service can constitutionally decline to give you tax exempt status because of that position you're taking. That's a really interesting case. Let me give you another one. It's called Bowen versus Roy. So there was a couple who were receiving AFDC, aid to families with dependent children, government benefits. And the government said, we're going to discontinue your benefits unless you get your daughter a Social Security card. Their daughter was, looked like she was 4 or 5. She was fairly young. And the couple said, oh, she has a card, but if she uses it too much, this number labeling too much, they believed that using the Social Security number too much at her young age would rob the spirit of their daughter. So they did not want to use the number for religious reasons. They believed it would rob their daughter's spirit. And the court rejected their claim. The court basically said, well, if you want to get the benefits, you will have to use the number. That the free exercise clause does not protect you in the sense that you can get to benefits and still decline to follow these specific rules, with the court holding, as in the Bob Jones case, that the government rule met the exacting level of review to infringe on the sincerely held religious beliefs. So, I mean, the cases go on. I've listed one at the back involving Native Americans and their attempts to protect their property and their cemetery property, and government's attempt to build a road through it, which would eliminate their ability to worship in the same way, to freely exercise their religion, but the court upheld that. So it seems as if that initially the court was using strict scrutiny and still does. But in some of these cases, it appears that the court was sort of easing toward, in my view, easing toward a lower level of review for government. And that became very obvious in a case called Employment Division versus Smith. So there were some Native Americans who were fired from their jobs. They had ingested peyote during a religious worship experience. They had ingested peyote, and then they were terminated. They were working for a drug rehabilitation organization. They said they ingested peyote as a part of their religious sacraments, and so therefore they should not be terminated from their employment. And so then the state denied them unemployment benefits. So the court, does this meet strict scrutiny? Well, the court said we don't have to meet strict, rational. The court said this is related to a criminal law. You were denied unemployment benefits because you lost your employment because you violated a criminal law related to illegal drug use. So the court said, even though the general rule is strict, in a situation like this with a general criminal law that denies your benefits because you violated that general law, all the law has to have is some rational basis. And here there was a rational basis to deny you your unemployment benefits for losing your job for violating a general criminal law, even though the Native Americans said that they ingested the peyote as a part of a religious sacrament. So this case had a huge outcry, and from Native Americans, from many people from different faiths. They were really concerned that the court may be moving from respecting their rights with a strict scrutiny, high standard, to a very low standard. There was legislation that followed, all kinds of things, but we ultimately are left with the general rule, it's strict, but sometimes rational basis. What do you think about this? Right now, after this case, there was a religious group, the Church of the Leukemia, that a city ordinance appeared to be targeting. This religious group, they used animal sacrifice, and the city decided to ban animal sacrifice. But some evidence showed that they banned animal sacrifice in a way of targeting this religious group. So the law said it's unconstitutional. Even though it's a general rule, the evidence shows you were targeting a religious group. And so therefore, it was unconstitutional. I know you're probably saying, now, what is she talking about? What is the court doing? You followed the strict scrutiny, but now it becomes sometimes rational, but sometimes not rational basis if you're targeting in all of these different cases. Some rights, are some rights respected more than others? We are continuing to have debates about these issues. One of the current debates we're having has to do with corporations and whether or not they have a right of free speech. Excuse me for a second. I had to go cough. I'm back. Whether or not corporations have a right of free exercise. And how does that fit in terms of employees and perhaps female employees who want to use contraception? Can an employer, how does that work in terms of their rights of privacy versus an employer saying they do not believe in birth control or certain types of birth control? And then we have the Affordable Care Act and all of that, those are some of the ongoing issues that are being addressed related to the free exercise clause and how it may also come in conflict with individual rights of privacy. Look, isn't it something? Learning is really something. Learning is powerful. I mean, learning can lead us on this path, a path to being more informed, a path to greater enlightenment, right? Learning can lead us on this path to freedom and justice. And sometimes I say justice, not just us, not just for us, but justice. And so learning can take us on this whole path so that we, the people, can have a better country and a better understanding of our Constitution. So subscribe and sign up for notifications, right? You don't want to miss a thing. In the next clip, I'm going to tell you about, I'm going to be away for a few weeks, but I'm going to bring you a next clip and tell you about some exciting work my students are going to be doing. Okay, you take care. Bye.